Good morning, everyone, and welcome to the South Carolina Department of Consumer Affairs 2025 Legislative Update. I am Carrie Gruby-Leibarker. I get to serve as the administrator and the consumer advocate for the Department of Consumer Affairs, and it's my pleasure to be here with y'all today. Part of my job duties as the administrator is to advise the Governor and General Assembly on issues that affect consumers. So I get to go over to the State House and talk about whatever laws are out there and how it may impact consumers. Sometimes we draft legislation that we think would be helpful as well. And so happy to be able to share some of that with you today and also share how you can get to that information and know who your legislators are, find bills and things along those lines too. But before we get started, we are going to do some housekeeping. And just a little disclaimer that this presentation isn't meant to serve as a substitute for reading any of the bills or the laws or anything that we talk about today, just trying to give a general overview of the subject matter. So our roadmap, we're going to talk a little bit about who we are here at the Department of Consumer Affairs, give you some insight into the South Carolina legislative process, talk about some pending bills that we're following here that did not pass this session, and then talk about a couple of new laws that did pass. So first off, we are the Department of Consumer Affairs. We are the consumer protection agency for the state, and we are celebrating our 50th anniversary. The law passed in August of 1974 that created the department and the Consumer Protection Code, and then it went effective January 1 of 1975. So we're celebrating all year long. We have 48 full-time employees, and we have one location in the state. We are located on Greystone Boulevard, which if you're familiar with the Columbia area, that's right by the zoo. We have over 120 statutes under our jurisdiction. The majority of that is the Consumer Protection Code. And I'll kind of give an overview of the industries and the areas that we regulate in a minute. So how can our department help you? So most folks know us because you can file a complaint with our office. So we usually, I would say, take in 3,500 to 4,000 complaints on an annual basis. But since COVID, that number has jumped to close to 6,000 complaints. And if the business or issue being complained about or against is regulated by another state or federal agency, we'll kick it over to them. If it's regulated by our office, the complaint will go to our legal division to see what kind of statutes come into play. And if the business or issue isn't regulated by anyone, which occurs about 8 or 9 out of 10 times, then our consumer services staff will engage in voluntary mediation of that complaint. So in calendar year 2024, we got, again, almost 6,000 complaints. The year before in 2023, it was 5757. Then last year it was 5869. And real estate transactions took that top spot. It has been in the top 3 over the last few years, but vehicles is usually number 1. So real estate eked it out. The majority of those deal with homeowner association complaints and timeshare related complaints. And then we have vehicles at number 2, which top subcategories there, usually vehicle repair, used car sales, and credit sales. Then we have contractors, utilities, ID theft, landlord tenant, internet, debt collection, consumer finance, and medical. Consumers can file a complaint by going to our website at consumer.sc.gov and can do it through our online portal. Or we also have a PDF complaint form that can be downloaded, and we're also happy to mail a complaint form to somebody. You can call us toll free at 800-922-1594, and we'll be happy to send that out to you. We also take scam reports and identity theft reports. We have an identity theft unit that was created in October of 2013, and they will field scam reports even if somebody did not become a victim of that scam, because then it helps us know what kind of tricks and schemes are popular out there and how the scammers are putting new nuances into play, because the bottom line for a scam is they're trying to separate you from your personal information or your money. That never changes, but we want to know what's going on out there. So those scam reports help us a lot there for the educational outreach, news releases, publications, presentations, things like that. But also if you're a victim of a scam, we may be able to assist you, especially if you've handed over personal information, on some free tools that you may have to limit the potential of you becoming an ID theft victim or how to catch that quickly. And then we also come alongside those who are victims of identity theft, providing one-on-one guidance, tailored support for that particular type of ID theft you may be experiencing. So you can file a scam form on our website, or you can just call us. Complaints need to be done in writing, but scam reports and identity theft reports, they can be done over the phone or online. And then this is just an example of some of the one-on-one guidance that we give for identity theft victims. There's a standard toolkit with all the items that apply to any kind of identity theft event. And then this sheet on income tax fraud is just an example of how we pull federal and state resources in a checklist to help you go through to mitigate the event. You can also utilize our website or contact us to background a business. We always want to make sure that people know who it is that you're turning your hard-earned money over to. So our department regulates 15 different industries. And as I mentioned, we administer and enforce Chapter 37, the Consumer Protection Code. This just gives you some examples of what kind of subject matter falls under that. It's usually credit related, credit sales, loans, rent to own, and leases. But we do have some industry licenses too, such as continuing care retirement communities, credit counseling, and there's some laws outside of Title 37 where it's usually industry-based, where they have to register or file with our office, and that includes timeshare resale and homeowner association complaints. But it really runs the gamut. Athlete agents, pawnbrokers, those credit counselors. If there's a consumer credit contract at the base, we usually have some kind of jurisdiction. And we have a website where you can check and make sure that folks have their proper license with our office. And then there are a lot of state agencies that regulate industries other than our office. And so we have a list of them to the Department of Insurance, the Department of Labor Licensing and Regulation, Secretary of State. Those are usually popular ones that we refer folks to. And then you can also search complaints that have been filed against our office or with our office. Just because somebody has a complaint doesn't necessarily mean you shouldn't do business with them. You want to see how they responded, but most importantly, that they did respond. And so you can find this webpage at consumer.sc.gov/background-business. It's also, if you scroll down on our main webpage, it's one of our buttons that we have there. And then some additional tips are there too for looking at interest rates and fees and asking for references, all that good stuff. We also give free presentations. Education is a core component of our mission. Here at the department, we want to make sure that businesses and consumers alike are aware of their rights and responsibilities under the various laws. And so we do free webinars such as this. We have a webinar Wednesday on a consumer topic every Wednesday at 10:30. And then we will go across the state in person. I know we have some folks in the Columbia area at a church today doing Ditch the Pitch Bingo, which is one of our most popular presentations that we have, where we take a tip and combine it with the number and the letter and go through that to help folks learn. But then we're having a great time. We have some DCA swag associated with that too. We also go out to homeowners associations and other community groups or events, with a booth. We don't necessarily have to present. And then of course with businesses, we've gone nationwide as well as within the state for different business conferences and teaching folks how to protect personal information and how to comply with different laws. We even got to go to Congress in September and talk about Ditch the Pitch, our guide for guarding against scams, and what we're doing in South Carolina and what we're seeing in the area of scams to educate lawmakers to see what the federal government would like to do in that area as well. And then we also just like to see ourselves as a resource. We're here to answer questions that you may have. We have a live receptionist at our toll-free number. We get about 25,000 calls annually. And if the issue that you're calling about doesn't fall under our purview, we can hopefully get you to where you need to be in a quick fashion. And then we use all sorts of different tools to try and educate through press releases, traditional media. We have different reports and publications, social media, and our website. And then of course, we talked about those presentations. On our website, you can get access to over 50 publications that range on topics from scams and ID theft to financial literacy. Credit Reports is a popular publication, and we have 6 that are available for mail order. If you go to our website, or if you want to call us, you can get up to 50 of them at a time. And that includes our Ditch the Pitch guide for guarding against scams, Credit Reports, what they are and why they matter, how to prevent ID theft, auto guide for consumers, and then recovering from a disaster. You can access the majority of services that I spoke of under the How Do I tab on our website at consumer.sc.gov. and you can click About Us to learn more about our agency. All right, so that's who we are here at the Department of Consumer Affairs. Let's go ahead and dive into the subject matter of today's presentation and talk a little bit about the legislative process here in South Carolina. So the South Carolina legislature is divided into two bodies. You've got the House of Representatives, which has 124 members, and then you have the Senate, that is 46 members. Together, they form the General Assembly. They meet annually from the second Tuesday in January until the second Thursday in May. And any member can put forth a bill to, suggestions for new law. And we have a 2-year legislative session in South Carolina. So 2025 was the first year of a 2-year session. And so essentially what that means is any bills that did not pass by the second Thursday in May this year, which I think it was May 8th, it was pretty early this year, then they just hold their spot and they'll pick up where they left off that second Tuesday in January of 2026. So we're going to talk a little bit about how a bill becomes a law and what that pathway looks like. Sometimes there are companion bills. So that means a bill that is very similar was introduced in the House or the Senate respectively, and they have a similar bill in the other body that was also introduced. I don't think we have a lot of companion bills this year. And then crossover is something that used to exist. It was to where a bill had to go from the originating chamber to the other chamber by the second Thursday in April in order for it to become law that particular year, unless there was a vote by, I think it was 2/3 vote for them to be able to consider it. But crossover was taken away this year through rules amendments on both the House side and the Senate side. So at this point, any bill can pass at any time. It doesn't have to cross over from one chamber to the other. It can be, it's up for being able to be passed without any kind of special vote until session ends. And then we're going to talk a little bit about how to get involved. There are so many bills that are introduced during a legislative session, and the legislators can only make decisions on what they think is best for South Carolinians in passing the law if they hear from the experts, if they hear from people who have an expertise or an opinion or want to make certain suggestions for that law. So we encourage you to follow the legislature and to let your representatives know if you have a dog in the fight or an opinion about a certain piece of legislation, or if there's an issue that you see that you think there's a gap in the law or something needs to be amended to address that particular issue. So here we go with how a bill becomes a law. So bills are read on the floor of the chamber where it's originating. So if it's a House bill, it'll be read on the floor of the House. If it's a Senate bill, it'll be read on the floor of the Senate, and that's the first reading. And then it will be sent to a particular committee to be studied. And usually it depends on what title it is going to be amending for where it's going to go committee-wise. Sometimes it's subject matter based too, and committees are allowed to accept, change, or reject a bill. And sometimes you'll see that on the floor. If something's referred to a committee, it could be as it starts going through its course, it belongs really in a different committee. And so they may make that switch. And then, so it goes into the committee. The committee gets testimony from interested parties. A lot of times you have lobbyists for particular industries that may be affected by the bill. You can have consumers that come in. You can have folks who participate in an industry professionally that the bill may affect as well that come in too. So once the committee has finished looking over the bill, which usually includes a subcommittee meeting or a couple of subcommittee meetings and a full committee meeting, where you have the full committee hearing about the bill and voting on it, where there's usually not testimony at the full committee level. It's only usually at the subcommittee level. Then they will vote on it. And if they are in favor of that report, then they'll create it and send that report to the floor of that chamber, and it will get a second reading. And at that point, the members of that particular body will have the opportunity to put up amendments on that particular bill. And so if it goes through the process, it'll be read a second time. It'll go to the third reading, where usually, there is debate. Sometimes they don't allow amendment on third reading. Sometimes they do. But once third reading is given to the bill, then it will go from the house originated in over to that second chamber, and then they'll go through similar steps as the first one, where they'll read it on the floor, they'll assign it to a committee. The committee may or may not hold meetings on it. They'll start with subcommittee meetings where testimony is given, kick it up to the full committee meeting where usually testimony is not, but they can request it. And then if they want to kick it out to continue it down the path of becoming a law, they can do so. So if both bodies agree with what the content of the bill is, then it can go forward to ratification. If it goes from the originating body to the second one, so we're going to use if it goes from the House to the Senate and the Senate amends it, it'll go back to the House to see what they want to do with it. And so the process can certainly be longer as they hash out any disagreements or things along those lines. But once they come to an agreement, ratification occurs and it goes to the governor, where he can either let the bill go and it'll become law after 5 days, or he can sign the bill to get it to become an act, or he can veto that bill. But if the bill goes forward, if it becomes an act, it'll have that force of law, and it has an effective date for when it goes into effect. Usually, most of the times it's on approval by the governor, but sometimes if there are some steps that need to be taken to give industry a heads up, or people who it applies to a heads up, or there's a new program or framework that needs to be established within the agency that has jurisdiction over it, there may be some extra time put in there for having an extended effective date, past when the governor signed it. There is a South Carolina legislative process brochure on the State House website, and it's at this particular link. Again, this presentation is going to be loaded in the chat, so you'll be able to access that. So during the first half of the 2025-2026 legislative session, there were 97 bills that became law. 94 of them were signed by the governor, and then one was vetoed by the governor, but then overridden. And then there are 2 bills that are pending because they were vetoed by the governor, but the legislature is not in session right now, so they'll pick that back up when they come in 2026. Over on the right-hand side, what I have is a record of bills and acts in the length of session for the last 20-ish years. There's a legislative manual that gets created every year. They haven't done the one for the most recent years yet that I could find online. So just wanted to give you an example of how many bills are introduced and how many pass in a year. So looking at 2022 and 2023, so 2022, there were over 1,200 bills introduced and 154 became law. And in 2023, there were over 2,300 bills introduced and 103 became law. So this is where bills can be found on the scstatehouse.gov website. You can do a quick search and put the bill number in or the topic of legislation in this search queue, and it'll pop up with everything that you may be interested in. So we're going to talk about homeowners associations a little bit later. If you're interested on legislation dealing with homeowners associations, you can put that in the search box and click the legislation button and click search, and all the bills that have homeowners association in it will pop up. I would recommend, sometimes, we think words like homeowners, some people think it's 2 separate words, some think it's one. And so put both in just to make sure that you're capturing whatever it is that you'd like. And if you know a particular bill number that you want to search for, you can just click that button, put the bill number in there, and then search there. And then you can also use the research tab, and that'll show you the different legislation that's passing. You can search budgets. You can search, I think, by whoever introduced the bill, what committee the bills are going through. Our State House website is a treasure trove of information, and it is really user-friendly to be able to track down items that you may be interested in. I'm going to pause there and see if we have any questions about who we are here at the department and the legislative process before we move into the bills that are currently pending. Okay, I'm not seeing anything right now, so we'll move forward. But please, if you have questions as we're discussing them, feel free to put them in that Q&A or that chat, and we'll make sure to get to them before the end of our presentation today. All right, so pending bills. We've put them into a couple of categories: lending, homeowners associations, and other. And I will just say, when you saw, more than 1,100, more than 2,300 bills get introduced in a particular session, I don't know how many were introduced this session, but we certainly don't follow every single one of them. We try and narrow it down to areas that fall within our subject matter jurisdiction so that we can follow those and see if there's input that we need to provide at any given time during that process. So this is by no means an exhaustive review of what is currently pending at the legislature. So first up, and then energy reform. Oh, that should not be there because that passed. Spoiler alert. So we'll get to that one later. All right, so on the lending side of things, so we have S379. It essentially phases out deferred presentment transactions, which is more commonly known as payday lending, and allows the folks that are in that particular industry to change over to supervised and lending licenses. We've seen that occurring ever since 2009, when a law was put into place that created a database for deferred presentment transactions, limited the amount of transactions consumers could have at any given time, and put some other restrictions in there. We've seen the number of transactions go from 4 million a year to a couple 100,000 in a year. And some of the big players in the payday industry have just switched licenses over to a supervised lending license. And in South Carolina, we don't have a limit on interest rates. So consumer lenders or folks that are engaged in consumer credit, they are allowed to charge any interest rate they want. But if that interest rate is going to be over 12% APR, they have to get a license from the South Carolina Board of Financial Institutions. And if the interest rate is over 18%, then they have to make a filing with our office as well. It's supposed to be one of those items that allows consumers to shop around for credit, but also to let industry players know what their competitors are charging, because it's supposed to help set the market rate. So the supervised lending license does not have as many restrictions as a payday lending law at this time. And so it just sets up the framework for that transition and the removal of Chapter 39 of Title 34, which is the Deferred Presentment Transactions Act. That particular bill, S379, it is a Senate bill. If it has an S in front of it, that means it is originating in the Senate. And it's in the Senate Banking and Insurance Committee. It was introduced at the end of February, and I do not believe that a meeting was held on that bill. And then we have S488. This deals with consumer credit. It talks about deferred presentment transactions as well as installment loans, which are general consumer loans. And it describes certain predatory consumer loan practices that are prohibited in the law, including some restrictions on live checks, which are checks that pop up in your mailbox. That it's almost like, a pre-approved credit card application, but it's for a supervised loan. It also creates a database similar to what we have for payday lending transactions, and has some loan limitations on that as well, for how many loans a person can get out at any particular time. This bill was introduced later in the session. It was assigned to Senate Labor, Commerce, and Industry Committee, and I don't believe that there's been a subcommittee meeting held on it at this point either. But again, it'll just pick up where it left off this past session at the beginning of 2026. And then we have H 4521. And this creates a statutory framework for litigation funding transactions. Litigation funding is also called lawsuit lending or pre-settlement funding, and it essentially involves an advance of funds to a plaintiff that's in a civil action. Sometimes it's for getting hurt on the job, and could be an auto accident as well. But essentially, the monies are given to that person because they're awaiting a ruling, right? So they're awaiting any funds, maybe a settlement fund. And so a company will come along and give an advance to that plaintiff in that suit. And whenever the suit is settled, or whenever the consumer gets that money from the lawsuit, then they'll pay a certain amount back to the litigation funder. If the consumer receives less than what's owed, then whatever the consumer gets is what's supposed to go to the litigation funder. If the consumer doesn't get anything, from the settlement or from the lawsuit, then they don't have to pay anything to the litigation funder. The department issued an interpretation back in 2014 saying that litigation funding is considered a consumer loan in South Carolina. And so the particular consumer protection code provisions that apply to loans would apply to a litigation funding transaction. But this particular bill would say that litigation funding is not a loan, and it has requirements regarding certain disclosures that have to be given, a requirement to register with the Secretary of State, and has different limitations and violations provisions. This particular bill was introduced, I think, in the last week or 2 weeks of session this year, and it sits in the House Judiciary Committee. All right, now moving on to homeowners associations. There's always a flurry of activity with homeowner association bills. And so if you have been on one of our prior legislative update webinars, some of this may sound familiar because it was the beginning of a 2-year session. That means everything that didn't pass in 2024 was done. And so you had to start all over. And so it may sound like similar content to something you heard before, but it's going to have a different bill number. So again, the H means that it has originated in the House. So first up, we have H 3350. And this actually resulted from our department going through the House Legislative Oversight Committee process. As a part of that deep dive into our agency operations, they ask about any statutory amendments that we think would be beneficial based on what we're seeing in our operations. And so our office back in 2018 was given the mandate to take homeowner association complaints. We're not allowed to arbitrate disputes. We're just allowed to engage in voluntary mediation of it. We issued a special 5-year report for all of the data, and actually did a 7-year report for all the data that we've collected since June of 2018 under that law, and kind of formulated some recommendations based on what that data was showing. And what we see a lot in homeowner association complaints is a lack of communication. And so one of the suggestions that we made, which is included in 3350, and I believe 3350 includes the majority of our recommendations in the homeowner association area, is a requirement for folks to have an internal dispute resolution process. We think if they can come to the table, they should have a good opportunity to hopefully alleviate whatever concerns there are that are going on between the homeowner and the homeowner association. And to make sure that people know that there is an existence of a process so that it can go through. You know, when people file a complaint with us, our first thing that we ask is, have you reached out to the business? We certainly encourage doing so in hopes that you can resolve the issue before having to file a complaint with us. And we think an internal dispute resolution process would be that tool for that kind of communication and resolution to occur. It also provides that certain provisions of the Nonprofit Corporations Act related to quorums, voting rights, meetings, and some other areas would apply to homeowners associations. The current law does have certain notice and disclosure requirements and the ability to access membership lists included, but it's a very limited amount of the Nonprofit Corporations Act that applies to all HOAs, whether or not they are registered as a nonprofit corporation. This bill would also give the magistrate's court jurisdiction over all matters between a homeowner and a homeowners association. Currently, the law does allow a magistrate's court jurisdiction over HOA issues, but it has to be where there's an amount in controversy of $7,500 or less. So there's that limitation there. And when you get attorneys involved, that can quickly exceed that $7,500 threshold and take it out of the magistrate's court jurisdiction. The bill also requires that homeowners associations include supporting documents whenever they're responding to complaints that are filed with our office. So again, you know, a lot of times what we're getting are complaints where people say the homeowners association did this and they're not allowed to, or the homeowners association didn't do this and they're supposed to. And whether that's under, you know, governing documents or the declaration, it would be helpful if, when responding to the homeowner association complaint, we could get a page out of the covenants or the restrictions or the governing documents that says, you know, this is where we're allowed to do this, or, you know, here's the meeting notice that we sent out or posted in our clubhouse or whatever, just to have something to show that whatever the homeowners association is saying is true and accurate, and it directly responds to what the consumer is complaining about or what that homeowner is complaining about. So that's H 3350. It was referred to the House Labor, Commerce, and Industry Committee, and that's where it resides currently. Then we have H 3425. that establishes certain financial disclosure requirements for homeowners associations, prohibits homeowner associations from paying utility bills on behalf of homeowners. And then there are certain requirements for the homeowner association budget, including notice requirements and a quorum to approve expenditures that weren't already approved in the budget. And 3425 is also currently in the House Labor, Commerce, and Industry Committee. All right, continuing the homeowner association bills, S366. This allows for specified flags to be displayed by a homeowner, a maximum of 2 of these. You're permitting it, and essentially saying the homeowners association cannot prohibit somebody from flying these particular flags as long as there's 2 or less of them in the yard. It requires disclosure of monies that are paid to an officer of the homeowner association, as well as disclosures of contracts that the HOA entered into. It limits the HOA's ability to restrict speech of its members and prohibits foreclosure on a debtor's primary residence for HOA fees. S366 was referred to the Senate Judiciary Committee, and that's where it lies. H3447. It requires homeowner associations with the authority to foreclose in their governing documents to first have a rule to show cause issued before they can proceed with their foreclosure. And essentially what a rule to show cause does, you have to go before a judge and justify your actions. So if you want to foreclose, you'd have to go before the judge and say, this is why we're wanting to foreclose. This is where we have the authority, and lay it all out. And the judge either says yay or nay. And so you have to get that yay before you can proceed with a foreclosure. Now, this is one of the homeowner association bills that actually did have movement. It passed the House and was referred to Senate Judiciary, and that's where it sits currently. And then we have H4006, and it's a catch-all for homeowner association issues. It has meeting notice requirements, an executive session framework, a framework for folks displaying political signs, how long they can do so, and that you can't, put fees or fines in place for expired tags on parked vehicles. People have to be allowed to fly the South Carolina state flag. And I think there are a couple other provisions there too, but that's in the House Judiciary Committee. I'm not aware of it having a meeting. And then our other category for bills, S325, it makes our agency, the Department of Consumer Affairs, a cabinet agency. We currently have a commission. The commission is our policymaking body of the agency. They are made up of 4 members appointed by the General Assembly, 4 appointed by the governor, and then the Secretary of State serves ex officio, and they appoint the administrator of the department as well. It's been a framework that has been successful over the last 50 years. It allows our agency to be impartial in our administration and enforcement of the laws that are under our jurisdiction, and it also allows for consistency and regulation as well. So we're watching that closely. It is currently on the Senate floor. H3351, it deals with timeshare contracts. And so this is another recommendation that came out of the House legislative oversight process. You saw real estate transactions as the #1 complaint category for 2024 earlier. So there were 1,135 real estate related complaints. 617 of them were homeowner association related, and 471 were timeshare related. And so part of that is the cancellation side of things. Currently, you can cancel within 5 days of signing a contract, but a lot of times folks come into South Carolina, they're on vacation, they sign up for a timeshare, and they're still on vacation whenever that expires. And so we're just looking to give a little bit more of a buffer for folks to get home, to get back to reality, have an opportunity to fully vet that contract if they hadn't done so before signing, which is certainly something we recommend. And I think Florida has 10 days for a cancellation, which is where we got that from as well. So that bill is in the House the House Labor, Commerce, and Industry Committee, I believe, currently. And then we have H3658, which requires DCA licensees and filers to include our telephone number and website address on contracts or otherwise give a notice to consumers via contracts or some other kind of disclosure. This also came from the House Legislative Oversight Committee. And it just goes to awareness. A lot of people don't know that our agency exists to be able to assist them if they have questions about a particular product or company, or if they wish to file a complaint. And so we have 8 industries that currently do have to put our contact information on contracts or in notices. And so this would just bring in some of the other folks under that same kind of requirement. There was a committee meeting on this. It's referred to the House Labor, Commerce, and Industry Committee. There was some concern raised by a couple of industries, and so we'll likely try and work on that in the off season and get something moving next year. Any questions about pending laws before we move on to the new ones? Let me check. So someone asked, would a covenants committee count as an internal dispute resolution process, which is independent committee from the board? So I don't believe that the law requires the internal dispute resolution process to be independent from the board. It would just be somebody who would be able to take in kind of that complaint or that concern from the homeowner, and there would be some kind of a hearing or exchange to kind of get to the bottom of it and to exchange information and to see if there could be a resolution. I don't think that it gets too specific into what it has to look like as far as the committee. It just gives a very broad overview of the purpose of the internal dispute resolution process itself. That's a great question. Okay, I'm not seeing any additional ones, so we will continue with our new laws. So we had a spoiler alert earlier, they're energy related. Both of the laws that passed, storm securitization and the Energy Security Act, deal with utilities. So just want to give you some background on the regulation of utilities in the state of South Carolina. So essentially electric, gas, and water utilities are monopolies in the state, right? There's no natural competitors within their region. They're assigned an area or a territory that they will serve. There's a bunch of different reasons why monopolies exist in the utility area. It's supposed to help lower average costs, it's supposed to help prevent duplication and investment in different services or plants, but there is regulation of that. So the Public Service Commission is the state entity that regulates utilities. And if a utility wishes to increase their rates or engage in other kind of activity where rates will increase, it goes through a Public Service Commission hearing process. And investor-owned utilities are who it applies to. And so it doesn't apply to co-ops or town-owned utilities. It's your bigger players. When you think in the electric area, it's Duke, Dominion. When you think in the water area, I mean, one of the big ones is Blue Granite. So those are just some examples. And then you have some other players involved. You have the Office of Regulatory Staff that really does a deep dive into the finances of the particular utilities, and they serve more as the regulator there. And then our office gets to intervene in utility rate making as well. We had the role from 1978 until 2004, and it was removed from our office and then put back in 2018. Looks a little bit different than it did previously, but we currently have the ability to represent residential customers' interests in rate making proceedings. We focus in on those that are specific requests by utility to increase rates. There are other filings dealing with energy efficiency and other areas where it would impact rates, but it's not that direct nexus. So if we have resources to go beyond that direct nexus of that rate filing and it impacts rates, then we'll look at those cases as well. And then whenever a filing is made at the Public Service Commission to increase rates, other parties are allowed to file to intervene as well. And so that includes your environmental groups. Sometimes ARP has been an intervener in these actions. Sometimes we've seen homeowners associations intervene, large users of utilities, military installations intervene Individual consumers are allowed to intervene. And when I say consumer, it's those folks that are using utilities for personal, family, and household purpose. A lot of times the word consumer covers all ratepayers in this area when people refer to it, but we're always looking at the residential customers there. You also have the opportunity to participate in public hearings if you don't want to intervene in the case itself, and your testimony can be heard by the Public Service Commission members there too. So that's a little bit of background that I hope will serve us well as we talk about these bills that became law this year. So first up, we have S-157, and it deals with storm cost securitization. So the law first passed in 2022. Duke had some debt, some storm costs that it incurred. I believe it was like 5 to 7 storms over a 7 to 10 year time frame. And instead of putting that as an item that they wanted to recoup through a regular rate case, which could be more expensive, they wanted this particular law so that they could utilize a bond instead to pay for the costs associated with those storms. And so it's essentially cheaper for ratepayers when those storm costs can be securitized in a bond, because debt is cheaper than equity. And, they have a high credit rating, and it's, folks are going to be paying these bills, but there is a threshold that in order to securitize the storm cost, in order to say, no, we're going to pay with those via a bond process versus a rate case, they have to make sure that there's a quantifiable net benefit for customers. And so back when we did the first storm securitization case after the law passed, which the first law passed by May of 2022, and then the actual storm securitization case for Duke started later on that year and went through about 2024, and it resulted in about a $35 million cost savings, about 20%, as opposed to if it had been put into a regular rate case. So we certainly saw that as a success. And then Hurricane Helene came along, and Duke indicated that it had about $500 million in costs related to that storm, which is a hefty amount. And so they wanted to utilize the storm securitization process, but wanted to go through and essentially take out phase one. There were 3 phases in the original statute, where it was a cost setting phase. It's like how much are we trying to get through the bond process, and ORS would do an audit, and there would be some back and forth there. And then there was the framework process, that was phase 2. And then phase 3 was the letting, the marketing, and the securing the bonds to see if there would be a quantifiable net benefit in the approval process over at the PSC. And so essentially, the amendment that went through this year got rid of phase 1. So now utilities are allowed to use estimated storm costs to get the bond. It allows it to move faster through the process, but ORS will be auditing those and verifying those costs, and there's mechanisms in there built in to the process that if for some reason they overestimated, that would be taken care of fairly quickly. So Duke, shortly after this became law, filed for their Helene securitization costs. We're wrapping up the new phase 1 of that process, setting up the framework, and are getting close to moving on to that phase 2. And over here on the right-hand side, this is something that you'll see when you look up bills on the Statehouse website. It shows you where, that it was introduced and whether or not it went in committee or out of committee, and how it passed and went through for the governor. So it's kind of your timeline there. And then you have more detail there below that shows when people added names of sponsors. It shows what committees they went to whenever they got the committee report. It got second reading and third reading, and moved from one body to the other body. And then you'll see it says view full text, vote history, and fiscal impact statement. Full text, it shows you all iterations of the bill. It'll show you the date and when things were amended. Vote history, so you can see who voted how. And then the fiscal impact means, as far as the state agencies are concerned that have a role in this, how much money is it going to cost if this became law for them to implement it? And so that's where you can see the fiscal impact there. And then we had the Energy Security Act. So this bill, I think it was around 80 pages. There were lots of iterations. There were lots of deletions. It went back and forth, as you can see on the right-hand side. It was introduced December 5th. It was pre-filed before the legislative session started. The House and the Senate have different pre-filing dates that you can go ahead and get bills out there. Sometimes they may hold special meetings outside of session to go ahead and start talking about those bills, but other times it's just trying to get ahead of the game so it can be assigned to a committee quickly and start moving through the process. But you can see it took from December 5th until the absolute end of session, the day of session it was ratified, for it to become law. And there was a lot of interested parties that provided a lot of testimony on this because it is such a vast bill addressing lots of energy related issues. So it was signed into law on May 12th. Some of the items, I'm just going to go over some of the highlights again, certainly not a substitute for reading the bill in its entirety, but it allows for joint construction by Dominion and Santee Cooper of a gas plant at Kennedy's in Colleton County. It creates a permitting reform process where it's expediting the ability to get permits. It expedites the appellate process for utility projects, and then it changed some procedures within the Public Service Commission. As it was being passed, I mean, folks said that they believe that it supports a diverse mix of electric utility generation, small modular, biomass, hydrogen fusion, things like that. But there also are provisions in here where it doesn't just apply, it applies to more than just electric utilities. So that's just something to keep in mind. And then as far as the part that does apply solely to electric utilities and will have a large impact in the consumer residential rate making area is the electric rate stabilization portion of the law. So it applies to Duke Energy Carolinas, Duke Energy Progress, and Dominion. No one has opted into the law right now. We currently have 2 rate cases going on over at the Public Service Commission for Duke, for their 2 entities, but haven't seen anybody opt in for this quite yet. And it essentially creates a procedure where the utility files yearly monitoring reports and rates are adjusted on that annual basis. So it's not a full rate case that we see, every 3 to 5 years. On average, it's a smaller proceeding, but those rates will get adjusted based on those proceedings. And they'll use criteria that were set in the most recent full rate case when they're doing the Rate Stabilization Act proceeding, but that previous case must be within 5 years, or else they're going to have to do a different rate case. So a lot of the testimony was talking about what this would produce is smaller bites for rate cases. I think the last increases, if I recall correctly, in a utility rate case, just for the request to increase those rates, was about $15, like somewhere between $15 and $18 a month. So theoretically, if you took that rate case, would it then be $3 per month during those years? There was testimony based on that, but we're not 100% certain. There was lots of questions by legislators on whether or not this would save money for residential customers. No one could say for certain. So we will be watching this and determining how we can best represent residential customers whenever we get to the point of having one of these utilities file the electric rate stabilization request before the Public Service Commission. So again, we're back at our statehouse.gov website. You can do the research on bills. If you want to watch, if you know that there's a hearing coming up, which over on the right-hand side over here, it's the House meeting schedule and the Senate meeting schedule. And if something is scheduled for live broadcast, you can click on it and watch it. You can also watch the House and the Senate chambers when they're on the floor in session. And then there's archives for all of the meetings as well. The ones that were streamed, there's archives. So if you've missed something, you can certainly go back and watch it there. So those are some important areas if you're trying to follow a piece of legislation or want to know what kind of debate that there was on a particular piece of legislation as well, and to know if you are looking to be involved in a particular hearing when that hearing is taking place. Hope that this was useful information for you. We really do appreciate you joining us. We'd love to see you on some upcoming webinars that we have here at the department too. So today we did the legislative update. Next week, it's going to be protecting deceased loved ones from identity theft. And then we also have a presentation on avoiding scams and ID theft in the workplace that we've targeted towards businesses, but it's also useful information for consumers as well. We're going to talk about some of the scams that we're seeing that apply to businesses, but really they're across the board to consumers and for businesses, and the tips are very, very similar too. So you could always pop on to that, or if you own a business as well, you may want to have some of your coworkers attend it. You can sign up by scrolling down to the bottom of our webpage, consumer.sc.gov, checking out the calendar, and then clicking on the registration link there. Okay, so somebody asked about S366, which is the outright prohibition for homeowners associations regarding foreclosure on a debtor's primary residence. And so the question is, if you can't foreclose, then how are they going to be able to get whatever's owed to that particular homeowners association? Is that in the rulings against homeowners of the magistrate's court? So you could certainly go into magistrate's court for that type of a proceeding if the amount is below $7,500. Outside of that, unfortunately, I don't practice in the area of homeowner association law. I'm sure that there may be additional items or avenues to where the homeowners association may be able to get those fees for those liens or past due annual dues or things of that nature, but I'm not well versed on that. But yes, the magistrate's court certainly would be one if the amount in controversy is below the $7,500. Okay, I'm not seeing any more questions. So again, thanks for spending some time with us today, and we hope you stay cool and have a great rest of your day. Thank you.